So is Medicare Secondary Payer compliance mainly about Medicare or CMS or HHS complying with the law? And what does that have to do with me?
Okay, well, those are probably not going to happen in that elevator pitch.
There's nothing like a straightforward topic for a discussion, and MSP is nothing like a straightforward topic. In this episode of Medivest the podcast, Natt and I attempt to cover MSP succinctly. We fail.
So the way I always try and explain this to people, I'm using my example. I'm using my analogy example here, is that I'm stuck with somebody in an elevator, and they ask me what I do. And I have to explain to them that I'm in MSP compliance. And then their eyes cloud up and they go to another world because they have no clue what I'm talking about. And especially when I start to try to explain it to them, they're like, okay, what floor am I on? Like, when do I get off of this elevator? It's like, so do you ever find yourself in that situation? And when you do find yourself in that situation, how do you explain to them what Medicare Secondary Payer compliance is and what it's all about?
I've had actually some experience with this at some conferences, right?
But you usually take the stairs.
I do that.
You're the healthy
kind of in the early morning thing. I'm going up and down the stairs. But like once I put on the suit or the business casual today,
That's right.
Sometimes I find myself in that situation, and I typically just discuss. It's the elevator pitch, the classic elevator pitch, right? But I'm not really trying to sell them on it. But I do explain to them like, hey, when somebody gets a settlement, you see the attorneys on TV, I got him this much money, or this guy got me that much money. I said, or situations where a workers' compensation, a person got hurt on the job and then they receive money specifically for their medical bills that will continue into the future. It's like, well, technically, if the person is on Medicare right now or is going to be in the reasonably in the future, pretty close in the future, they're not supposed to use that settlement money inappropriately. And let me back that up. I should say this: they're not supposed to bill Medicare for the conditions that they were compensated for, right? So they can use their settlement money for any reason except for the fact that they're not supposed to have Medicare pay for their injury-related, condition after the settlement for going forward. So the idea there is that, in other words, the concept of billing Medicare or just having Medicare pay for that compensated injury-related condition, right? So those are like anything from, wheelchairs, crutches, so there's, durable medical equipment, the items, or the medical services or diagnostics, right? Or even prescription drug expenses, that if those medicals, let's call all those medicals, if those medicals arose from the injury that you were compensated for, you're not supposed to have the providers bill Medicare for those. You're not supposed to bill Medicare for those. You're receiving compensation from a third party, whether it's the employer, right, for workers' compensation, or from the insurer for somebody that committed negligence, or maybe an employer that was self-insured, or any entity that was self-insured that just didn't have insurance or chose to take that risk on themselves, right? Those are in the world of Medicare Secondary Payer compliance. Those are called primary plans. I already blew the elevator pitch.
We're in the Wonkavator at this point.
I'm just telling you,
we're straight. Charlie Bucket is on his way.
We went to the top
over some.
I hit all the buttons, by the way. I'm sorry.
Of course you did.
I hit all the buttons, and
you're elf,
and I had a hard time.
Well,
but I was really like, "Hey, don't you want a Medicare set aside?" And they're like, "What?" No, I'm just kidding. But
I just got a chocolate factory. Why do I care about an MSA? No, I'll go with the compliance word. right?
Right.
I mean, you must comply. There is a standard you have to conform to. It's compliance. But if you ask the question, isn't the expectation on Medicare not to pay? Right? I'm getting a little ahead there, but you have some laws that dictate that. And you've got the law that established Medicare as an insurance. And then you have a statute that was enacted, effective. I don't know what year it was effective necessarily, but I know it's 1980. We just had that conversation about whether it's effective in the year. That's a rabbit trail. But you have at least a statute and a law that dictate that Medicare is not supposed to pay, and it puts the obligation on Medicare, right?
That's right.
So is Medicare secondary payer compliance mainly about Medicare or CMS or HHS complying with the law, and what does that have to do with me?
Okay. Well, those are probably not going to happen in that elevator pitch or discussion.
Okay, we're outside the elevator now. We're in the lobby.
So now So, but what I do like to try to get the consensus with somebody is to understand, hey, if somebody receives this payment and they go, oh yeah, I understand that. You say, by the way, yeah, like insurance, when insurance sometimes wants some money back, like that's like Medicare. Medicare, if they pay for something and then they find out that you've been compensated, they have this right to get paid back. So, the statute, the Medicare Secondary Payer statute, it added to the Medicare law that was in effect, which added, to the Social Security Act that was in effect all the way back to 1935. But basically, the Secondary Payer Act added teeth to the Medicare Act of 1965, right? That actually put workers' compensation as the primary payer and Medicare as a secondary payer back way back to 1965. But Congress, right, determined after some, factual findings that that the Medicare Act itself didn't have enough enforcement. So they enacted this secondary payer statute, these provisions, the Medicare Secondary Payer Act or statutory provisions, that just adds to this blockchain of law that says, one, you're allowed to pay if somebody doesn't pay promptly, but you should not pay. So it's kind of strange. So like you should not pay if there's a primary plan in place, right? Any of these.
You being Medicare, you should not pay.
Congress was saying to Medicare, do not pay. You are prohibited from paying unless there is not a prompt payment, which is determined it was determined as 120 days under the regulations, right? So, and in workers' compensation or maybe no fault, like no fault insurance in a car accident, you have PIP, personal injury protection, or homeowners has something called MedPay. Those types of scenarios of workers' comp, no fault, PIP, or MedPay, those are relatively cut and dry. Like somebody either does have this claim or doesn't. Like, for workers' comp, did the accident happen in the course and scope of employment? Did it happen? Yes. Then they pick up and start paying, right? So we can go into the acronyms that are used at a later date, but that's the world of workers' comp. It's like, did it happen on the job in the course and scope? It's like, yes, then we're paying. The employer's paying. No fault insurance. Did it happen in a car? Yes. Then the no fault insurance is primary and starts paying. But liability is a different animal, right? So liability, a case happens, there's questions. One person turned in front of another. The argument is the other person was speeding. But the person that made the turn, and under many jurisdictions, they still have to yield a right of way. So which one was at fault? Probably both of them, or maybe both of them. So you have these issues of, is it a comparative negligence jurisdiction or a contributory negligence or some other hybrid of those? So what happens in those situations is, whether it was a self-insured or if it was a insurance plan that's in effect, nobody's going to admit liability ever, even after the settlement, but they're certainly not going to pay for the other party's medical bills right after it happened. They want to do their investigation. So that's why people hire attorneys and they go through this process. And what happens in that case is, if Medicare was, if nobody's paying for this poor person's injury, their medicals associated with that injury, the system's broken, right? So Medicare says, or Congress allows, I should say, in the Medicare Secondary Payer statute, allows for that opportunity for Medicare to make a payment, but conditionally. So under the condition or on the condition that if they do pay for an injury-related condition, that they are not only entitled to be paid back, but that they must be paid back. And specifically, it's a mandate to Medicare to recover the payments. So they're like, don't pay, but if you do pay and chase, essentially. So, right? So Medicare Medicare's under this obligation, but by statute, they also place anyone that receives payment or a portion of those proceeds from a settlement to be jointly and severally liable for the repayment to Medicare.
Okay.
Does that make sense? So,
It does. So,
yeah.
So my next question then is, for those who stumble on, like my mother will be one of the people watching this. She might be the only person watching this. She'll watch it for a while, and then she'll turn on the news. But for somebody who's watching this and asks the question, okay, so who has to worry about this? So who are the parties out there who would have to even be concerned about Medicare secondary payer compliance? Why would they even have to be? Is it just the injured party? Who is it?
Well, it's the injured party because they're receiving some of the proceeds. The attorneys that would represent the individual, right? So if it was a workers' compensation claim, that would be the claimant, applicant, or petitioner, as those terms are used for the injured party in workers' compensation. Or if it was a liability case, it would be like the plaintiff's attorney, typically is called the plaintiff. And that attorney, because they typically receive a portion of the proceeds, a contingency fee is often the term used. And then the actual payer, the primary plan and the payer, so the insurance companies that pay, or the employer directly if they're self-insured, or even in a liability sense if it's a self-insured entity. And then actually medical providers, because they're sometimes they're indirectly receiving a portion of the proceeds when the party is seeking medical attention after a settlement. And so all those parties are potentially, they're in the firing line, so to speak, of the enforcement mechanism for when that pay and chase happens, if the chase happens, right? So, and it's interesting that federal statute, the MSP, discusses what these conditional payments are. They define the conditional payments. It's like the compensated, injury-related medical items. It's like items, services, and now after 2006, now that there's Part D prescription drugs, it includes these expenses, including prescription drug expenses, that they put those as part and parcel of the ability to recover. So any payments made for those medical items, services, or expenses, those are part of what those are considered conditional payments. And those exist under the federal statute, whether it's up until from the date of injury into the future. So in other words, the statute does not make some sort of arbitrary or
Doesn't delineate.
They don't delineate. They don't make a distinction until the date of settlement stops a payment that's made by Medicare from being considered or called a conditional payment. In other words, a payment that happens 2 years after a settlement, if it's injury related and Medicare covered, it is a conditional payment under the definition of the Medicare Secondary Payer statute.
Mm-hmm.
What's interesting is that the operation of the law, or the way the law is implemented by CMS, which is the Centers for Medicare and Medicaid Services, right? They're an agency under the Department of Health and Human Services, but they're responsible for administering this the Medicare program in its entirety. They have chosen over time to essentially set this line of the date of settlement as a very important date. And so all the parties, right, including those that are jointly and severally potentially liable for these, a portion of the payment or all of the payment back to Medicare,
Mm-hmm.
have kind of gotten very comfortable in a status quo setting, that, okay, if it's a liability case, we just have to check to see if we have to pay back Medicare.
Right.
For anything that happened from the date of injury up until the date of settlement. And then after that, we're not responsible anymore. And whereas workers' compensation, CMS has, not only do they have regulations that are specific to workers' compensation, and they have some regulations that are general, therefore should apply to all primary plans, they've actually written guidance called the Workers' Compensation Medicare Set Aside Arrangement Reference Guide.
It's a beautiful name.
It's just,
rolls off the tongue.
We'll call it the reference guide, but it's guidance. It's not the law, and it's not even the regulations, right? It's not the U.S. code, the federal law, and it's not the Code of Federal Regulations that are, kind of part of the book side of it.
Mm-hmm.
It's lower in authority, but it is followed by the industry, the stakeholders of the industry. And this reference guide makes this distinction between date of settlement. So like in the workers' compensation field, the employer pays for all the medicals for the injured party from the date of settlement, from the date of injury up until the date of settlement, right? But then when they pay money to an individual that was injured on the job, there's something called a compromise and release, or a settlement. And that typically goes in front of a judge of compensation claims, or in some states it's called the Workers' Compensation Bureau, it's like, or a board, but basically there's somebody that makes this decision, and they kind of approve or bless the settlement. And then everyone in that setting kind of makes a decision that they are going from that day forward, from the settlement date forward, the money that they receive in compensation from that injury is the responsibility of that party to use to cover anything that's injury related and Medicare covered, right? So they're not supposed to bill Medicare, but it can still happen.
I mean, I remember it's been quite a while. I've been in this industry about 20 years. But I can remember going to, I want to say it was CMSP certification program, and having the conversation, someone making the comment that there was no such thing as a conditional payment for services post-settlement. And I got into a debate with them about that.
Well, that's why they probably changed the name to the MSPN now.
Maybe. Well,
no, I'm kidding. But Medicare Secondary Payer Network. So no, but yeah, I think that was a good idea to get into an argument, because it's
it was a friendly argument,
right, or discussion.
But the idea is, if at the end of the day, if Medicare is making a payment at any time after injury for for something they're secondary to, there's a clear expectation they should be reimbursed.
Absolutely.
And that does not terminate with settlement. That doesn't go away at that point.
Exactly. Well, that's exactly. So what's interesting is that the workers' compensation industry, I would say in general, has done a good job of like understanding that and recognizing that's the whole purpose of, this, an offshoot, and it's maybe not the subject of this particular podcast, but is kind of saying, okay, so how can we settle cases, so from the insurance perspective or from the injured party's perspective, in a way that doesn't burden the Medicare system, doesn't shift the burden of payment to Medicare, the Medicare trust funds, right? So, there's technically two trust funds. No one really talks about whether there's a third trust fund for Part D for prescription, but I think there probably isn't, because those are all privately administered plans, whereas the traditional Medicare, you have your hospitalization under Part A, and then you have your doctor visits and some physical therapy and some other things, infusions under Part B. But those two plans, and there's some differences, like Part A might be covered in its entirety as long as you worked sufficient quarters, and Part B has you have some payments for that. You have to make premium payments, and sometimes you have co-pays or co-insurance. But the funding of those trust funds are have been more recently. The reason why the MSP was actually enacted was to help protect the trust funds, the Medicare trust funds. And, we're getting closer and closer, just like in the world of Social Security. These are entitlement systems based on individuals that have worked into and paid into the system, right? But the fact is that somewhere along the lines, like operationally, there's more expenses than revenue, and that presents a problem. So we're getting to the point where the Part A funds are slowly or maybe more rapidly depleting, and so something had to be done. So that's what the enforcement mechanism. So the workers' compensation industry has done a pretty good job. They've actually, like the concept of allocation companies like Medivest or many of the others out there, they have people that specialize in reviewing the medical records and estimating what those future medicals are going to be for a person going forward, and then giving them the opportunity at the time of settlement to decide, okay, now somebody has determined, professionals have determined what is likely for you to experience for your medical needs in the future that are specifically injury related and Medicare covered, right? So if it's injury related but not covered by Medicare, that's really not part of the MSP world, and therefore wouldn't be part of what would be called a Medicare set-aside allocation report.
Well, let's get into those.
Okay.
Need help with lien resolution, Medicare set-aside allocations, or professional administration? Medivest has you covered. We're here to guide you every step of the way. Visit medivest.com or call 877-725-2467 today.
Well, let's get into that. I mean, there's that litmus test of that intersection of Medicare allowable and injury related as being a test to determine whether it's
kind of a big deal.
A little bit of a big deal. But we can talk about MSAs, but I think it might be good to hit on the main ways in which the industry and CMS interact with each other to ensure compliance or promote compliance or affect compliance. I'm thinking of, and tell me if I miss any, thinking of Section 111 reporting. I'm thinking of the conditional payment, and I mean, you can call it a lien resolution if you want to get into conversations whether a conditional payment represents a lien or constitutes a lien. And then the Medicare set-aside piece, which is the future medicals post-settlement, what to do there.
And then maybe the administration of those funds. Whether it's self-administered or professionally administered, but basically that using the money in the appropriate way.
Mm-hmm. So Section 111, what's a high view explanation of what people who have heard Section 111, what actually is that from a high level?
Okay. So in the federal statute, in the MSP statute itself, right, under paragraph 8 of, the 42 U.S. Code 1395 YB2, right? And then you go. But
it's one of my favorite paragraphs.
Yeah. There's a paragraph in there that discusses a requirement, right? And the requirement of the insurance side, let's just call it that, right? Because plans aren't always insurance,
right?
But the primary plans, but the entity that's making the payment, they have very technical acronyms or technical terms, responsible reporting entities. But basically, the party that ends up paying the settlement has somebody, an agent. They call them an RRE, responsible reporting entity. And they have an obligation to electronically report information about the settlement and about the individual to whom they are paying the settlement, including all sorts of things like the injured body parts.
Mm-hmm.
And interestingly, just as of April of 2026, part of that world. So that's called Section 111 reporting because that was under the public law Section 111 that essentially under which that paragraph 8 in the MSP was enacted.
Why does CMS want that information?
Well,
how do they use that for compliance purposes?
Right. Well, it's really to help them as they gather more and more information. So they have the MSP statute has been amended several times to allow CMS to have more visibility on settlements, and even like the privately administered plans, like the Medicare Advantage plans, as well as Part D plans. Which are often bundled with the Medicare Advantage plans. But the Advantage plans are privately administered Medicare, so you have, instead of Part A and Part B, they call those Part C plans, and then they're often bundled with this Part D. But basically, we'll call them all Medicare for this purpose of this podcast. Medicare is, they do get visibility through this Section 111 reporting, so thinking of it like in the liability sense, it's the defendant's side or the employer side in workers' compensation of all people that are current Medicare beneficiaries that have settlements over $750, right? Or that have started, if it's a workers' comp, once they've accumulated payments or they have ongoing responsibility of medicals, the ORM is in place, they're getting these reports on a quarterly basis. And there's a $750 threshold. So basically, if you think about it, it's all like almost all settlements when they have the actual settlement at the end, which is called a TPOC or total payment obligation of claimant. And they use the word of claimant there, or that term. Interestingly, in theory, it's like if Medicare makes payments and they're entitled to this reimbursement because under this pay and chase concept, this is the obligation of the claimant. So they're looking at it as the obligation of the injured party, the claimant, to be paying back Medicare. So they're gathering this information so that they can, one, if their computer system is doing what it's supposed to be doing, and they talk about that in the reference guide, being flagged. So they have something called a common working file, CWF. But basically, their computer system is making note of the injury-related conditions, right? So if it was like...
This is intended so they can just avoid paying. They can know that
they could deny, exactly. So they could deny payment for things that are injury-related and Medicare covered going into the future. So, right, so, and then, but it could also identify those payments that they have already made. So, maybe their system isn't flagged immediately, or their flagging system doesn't integrate well with their payment system to the point that when a provider sends a bill to them, a bill still gets paid. It could happen, they missed it by 30 days or 45 days or 2 years, right? So, there's this.
I can't imagine a situation where two or more government systems don't work well together. I just can't fathom that could be possible. I also don't think there's a single claimant on the planet that is aware that Section 111 is happening on their behalf. And
That's right.
Yeah, and there's nobody knows that. But essentially, they're trying to give us the information so that we can ensure, among other things, we're not paying on that, and you're not building up a conditional payment balance that's going to result in a demand prior to settlement.
Exactly. Or after, or even that's ideally even after settlement. That's the idea, is that they're capturing the information, right? So they have different. It's kind of unusual, but they have subcontractors. CMS has its own contractors. They put them out to RFP, request for proposal, and private entities are charged with the responsibility of doing things like receiving the Section 111 information and then making recoveries for, on the workers' compensation side, typically against commercial entities. So they have like the CRC is the acronym for the contractor, although the contractor itself will have a different name, right? It's like a private entity. But the CRC is the Commercial Repayment Center. And then for the claim, on the claimant side, recoveries against the claimant. So that could be a workers' comp claimant, or it could also be a liability plaintiff. That those recoveries would be done by what's called the BCRC, the Benefits Coordination and Recovery Center. And so, and their systems are similar. I mean, in the past, it was the code writing was by General Dynamics, essentially like their software program. But their letters come out pretty in a similar fashion, and what they call their conditional payment letters, right? Sometimes they're conditional payment notices, but when they do identify what Medicare believes is a conditional payment, they'll list those on what's called a payment summary form. So it comes along with the letter. And that's where people, if it's, from the date of injury to the date of settlement, that concept, that's the whole conditional payments recovery process.
So Section 111 is assisting them to avoid payment, be aware of certain information about the claim. Also, and we'll talk about this in another episode, but actually collecting the Medicare set-aside number, which is a brand new development, kind of a hot topic. We'll get to that.
Absolutely.
But we're drifting very naturally into the actual recovery of payments that they've made prior to settlement, so they can make sure that they're complying there and that is taken care of before you settle the claim and move on.
Exactly. Yes.
So,
and the individuals representing claimant applicants in the workers' compensation industry oftentimes just say, hey, by law, the employer is responsible for making those conditional payments. But I would say that it's a good idea for those individuals to take a more active role in monitoring the conditional payments. And the reason I say that is I have seen, because our company also does the administration of these Medicare set-aside funds post-settlement, I've seen the unfortunate scenario where we will have a funded Medicare set-aside account, which is specifically designed and funded to cover the injury-related Medicare-covered medicals from the date of settlement on.
Yeah, I see where you're going here.
Yeah. And but what happens with the dates of service when they were after injury but prior to settlement, and the employer was supposed to pay, right? But they didn't pay, but then somehow Medicare does pay. So Medicare system's a little flawed. It's somehow, the reference guide actually discusses that in a few different sections. And we have actually pointed that out, and I know that there's been some discussions with CMS regarding this. But sometimes if nobody pays, right, but those payments are still due,
Mm-hmm.
There's going to be, somebody, right? Somebody needs to advocate for that injured party, right? So if it's an employer that's interested in helping that injured party and their attorney, they should decide who's going to pay for any dates of service up until the date of settlement if it's discovered after the fact, after the settlement, that those payments are owed, right? And we know that what happens is if Medicare paid those, but people didn't realize it at the time, and providers typically have up to 1 year to submit their bills to Medicare.
Right.
So it's kind of an unusual scenario, but there are times when these bills can be significant, especially if the settlement wasn't as significant. And all of a sudden, a person gets a conditional payment letter from this BCRC after a settlement. And then they come to maybe the professional administrator and say, hey, you're handling our Medicare set aside.
Or they're self-administering. They look at their MSA funds and they say...
Or they're self-administering, and then they're like, wait a minute, this happened before. This should be paid by... And they've already signed that compromise and release, and they've made a statement that they're going to take care of anything related, regardless. And so the language...
Regardless of date of service.
Right. So the language is important. And so advocates for parties should do their best to really clear up those things so that there's every contingency is considered.
Mm-hmm.
Yeah.
So Section 111 reporting, we talked about lien investigation, lien resolution for Medicare there, them recovering. We're going to talk in another podcast about when Treasury gets involved and what that looks like. But then you touched on the MSA. Quick overview of what the Medicare set-aside is, what it is, what it's used for. And I think that's going to be a great place for us to wrap up. So, high level, what is a Medicare set-aside?
Okay, so it's usually a written report it's written by professionals that have reviewed medical records, and they've looked at the conditions that are being compensated or to be compensated. Typically 2 years worth of medical records for each of the conditions that are involved in that particular claim, right? They're going to look at things such as the individual's pre-existing conditions or any other kind of comorbidities. So things that could affect their longevity, because what they're looking at, and this essentially stems from this reference guide. CMS has kind of set forth its methodology by which professionals, so our company uses nurses, they're going to review the medical records and look at what is reasonably expected in this injured individual's future for their entire life expectancy that are injury related and Medicare covered, and then they're looking at the medical items, the medical services, and the prescription drug expenses, and those, the pricing for those are done by coders, and so then they can also look at some Medicare set asides will also list as a separate item the non-Medicare covered medicals that a person can reasonably expect to see in the future, just so that they get a better understanding of what to expect.
Like.
Yeah, so that hopefully so the parties go into that settlement with eyes open. More complex settlements sometimes need economists to also estimate all the economic losses that may be experienced, and also with catastrophic and other more complex injuries, sometimes people will hire professionals that are called life care planners that will look at all the different things, some of the things that typically would not be Medicare covered but could be very expensive, like modifications to their housing, modifications to their transportation, if they can drive a vehicle with modifications, and or whether what are the expenses that are going to be needed for them going forward, including but the Medicare set aside allocation reports are very specific, so they're injury related, Medicare covered from the date of settlement moving forward for their life expectancy. And there's a technical side of the medical, like the underwriting side of evaluating how long a person's going to live based on what's called the life tables that are put out by the federal government, and then based on what the conditions are. If
you ever want to be depressed, go look up.
Yeah.
Go to the CDC life tables and figure out what year they've predicted you're going to die.
Exactly.
So
try to stay healthy. Try not to have those comorbidities. But
right.
We all have. Unfortunately, over time, it's like the longer we live, the more likely we have something that says we have some sort of condition that could affect.
Starts to ding that number down.
Reduce that number, right?
So you're going to take a Medicare set-aside allocation. You're going to look at that report. You're going to get the number, and then that's going to inform the settling parties how much money they may want to put towards that injury to be used in place of Medicare picking up the tab going forward.
That's right.
So that's money intended to get in front of Medicare and pay on its behalf so that it remains secondary. I guess we should have cleared that up when we say secondary payer. We are very simply meaning Medicare pays second.
That's right. That you're going to use the settlement money, because the primary plan is the entity that pays the settlement, and then all of a sudden the settlement money now is the primary money, right? So it shouldn't be Medicare should not be primary. So Medicare shouldn't be paying. It's the it's the settlement money that should be paying essentially, and really, and this is where this guidance. That was essentially established to encourage essentially workers' compensation parties to go to Medicare, right, to CMS and submit these allocation reports for their review and approval. And they use it's a voluntary process. It's interesting, but they have language interspersed throughout their reference guide that sounds like it's mandatory, and then it's like, well, and there's actually two spots in the reference guide that uses the exact same language, but they change one word. And so in one situation, they're like, it's voluntary, but if you do submit a Medicare set aside to CMS for review and approval, you must do X, Y, and Z. In another spot in the same reference guide, as it exists today, the most recent edition says the exact same thing, but it says, we request. So in other words, it's like, it's still it's a voluntary process. It's always been a voluntary process. And then, but if you do submit it to CMS, we request that you comply with. So it's like, well, which one is it?
Right.
It's like, but there are parts of we like to kid around because it's like a patchwork quilt, just like the laws of the U.S. Code are, because it's different members of Congress that are putting forth the laws in the federal statute. Different people at CMS are putting forth the different provisions or sections in their reference guide, and it's probably time for somebody to kind of go through and clean some of it up and make sure that it is more consistent, but. They've generally speaking tried to do a good job of getting people to recognize that there's this federal statute out there that says Medicare is secondary, and here's a way. So their big picture idea here is that if you do submit it to them, right, you chose to do it, but if you do submit it to them and you get a response back, whether you like that response or not, but that response that you get back, their approval essentially, but it could be a counter higher,
right?
Arguably, it could be a counter lower, or it could be an acceptance of the amount that was estimated. But whatever that number is, that you could be assured that as long as the money that they come back with their response with is used appropriately, that the individual will be entitled to Medicare coverage even for those injury-related and Medicare-covered conditions into the future after those funds are properly exhausted, right? So it gives some assurance, and there's plenty of claimants, applicants, attorneys that they want that assurance,
And with
that
that piece of
feeling of
paper.
assurance,
Yeah.
right? But certainly with the advent, and we could possibly have an entire podcast on Section 4.3, which was one of the newer.
Stay tuned.
One of the newer provisions, that came out as a big shock to the industry, and then it kind of got
Pull back.
it got
Hemmed.
walked. I'd say walked
It got
back.
hemmed a little
Yeah,
bit.
it got hemmed a little bit, and ultimately giving some of the industry stakeholders an opportunity to evaluate: is it the CMS methodology that must be used? Are
Right.
there evidence-based medicine or other non-submit type of estimations that would still be reasonable in the estimation of the people's future medicals?
The topic.
Stay tuned.
The topic is replete with rabbit holes, potential rabbit holes.
Yes.
Okay, well, I think that's probably a good place to pause. Yeah, we talked a little bit about CMS submission, but didn't really get into that too deeply. We'll get into that later. Obviously, we can talk about that more. But I think this is a great place to wrap this one up. Thank you.
You're welcome.
Appreciate you, Nat.
Sounds good.
You're the best.